We're just going to just dive right into the information that we have for you this evening. I'm sure most of you you've joined, you've made the effort to join. You're concerned about what's going on in the workplace with the new executive orders being issued by the administration this past week. So the way we're going to proceed this evening is I'm going to just give my presentation, and then we're going to take questions from the audience. We're going to ask you to, I'll ask my legal assistant, Kaylin, to just type in the chat how she wants to receive the questions and how she can get the questions to me so that we can try to answer your questions. We started out just with a small number of people, and it kind of grew from there. And so now I think we're up to several hundred people here. So this lets me know that this is a major area of concern that we need to address. All right, so welcome to the Federal Employees Workplace Rights webinar. And we saw on really January 20th, 2025, inauguration night, that the president issued a number of executive orders. One of the executive orders that probably concerns most of you deals with DEI, diversity, equity, and inclusion. And I want to just really start just kind of with the definition of DEI. It's much broader than what it's been painted or portrayed as in the media. Many of you know that your DEI, your agency has a DEI office, and for some agencies, all of the EEO programs are housed in the DEI office. So the very thought of just eliminating the DEI positions and then eliminating the DEI programs, it's very concerning for a number of you. The first issue is it's not just EEO training, but it houses all of, in many agencies, most of the EEO programs. We've heard reports that for some of our clients who are deaf or hard of hearing, some of the federal agencies house their interpreter programs in the DEI office. We had a client just last week who is a DEI program manager, and all of the programs, for example, Black History Month or Hispanic Awareness Month or whatever cultural group awareness month, it's all housed in the DEI program. So the elimination of the DEI program has rippling effects throughout the agency. And so the question is, what's going to happen now that these DEI programs have been are going to be eliminated? I'm just going to read. I have in front of me the executive order that was issued by the president, as well as a memorandum issued by the Office of Personnel Management on January 21st, 2025. And for those of you who heard the president's inauguration, as well as and you witnessed the signing of executive orders in his office, in the Oval Office, that was January 20th, January 21st. There were actions taken by OPM to implement the executive orders. One of the memorandum that was issued is the memorandum that I just referenced. It's the initial guidance regarding DEI executive orders. And it says effectively no later than January 22nd, 2025, that each agency is to inform OPM of all of the EEO employees who are in DEIA offices and to place them on administrative leave. So many of the people who had the DEIA or DEI offices have been placed on administrative leave through January 31st. And on January 31st, the agencies have to report back to OPM that there's a plan in place to separate these employees from employment. So for a number of people, this obviously is a great shock to learn that you no longer have a DEI officer and the office is no longer there. and the programs that are being administered by the office. There's some concern on what's going to happen with all of the programs. So we have DEIA officers or directors or people who are responsible for these offices who've been placed on administrative leave. And on January 31st, these people are going to be subjected to a reduction in force if no action is taken to stop this executive order. The president also issued a couple of other executive orders. One of the executive orders that you've probably heard about in the news was the executive order that essentially says that people who are, even if your parents are immigrant, if the child is born in the United States, that person is to not have citizenship. And that's been challenged in a federal district court in the state of Washington, and the judge there has issued a temporary restraining order. So that is not going into effect. Many of you have heard of Elon Musk, and you know that he was appointed to head up the Department of Government Efficiency, a DOGE, and that action is being challenged in Washington, D.C. by a public citizen, basically making the claim that this is not a valid department and it does not comply with the law. There's some concern about whether this office or department is operating with authority to do so, and with open, so that all of the business that takes place there is open. So that there's a challenge. So there are at least two challenges. There are other lawsuits challenging the executive orders as well. The problem is we don't have a challenge yet to this decision to eliminate diversity, equity, and inclusion. And I'm hopeful that from, maybe a conversation here tonight or something that we will hear from you online, that someone will step up and decide that they want to at least get this issue before the court and do so within the next week before this goes into effect. This is a fight, and it's a fight that I think that there are probably some valid legal arguments that can be raised to challenge the elimination of the diversity, equity, and inclusion offices. But what's going to happen, or what needs to happen, is someone needs to step up and file a lawsuit and request a temporary restraining order, at least request a hearing before a federal judge, and to do so this week before for the people who are in these positions are completely out of the positions and these offices are dismantled. Now, let me just walk through what's going to happen. I mean, what should happen if there is an executive order that either violates the Constitution or violates some law or some policy. And we're highlighting DEI because there's really been an attack on DEI. We saw that the president has appointed at the EEO Commission a chairperson who is a former partner of a law firm, one of the largest law firms really in the US, representing employers. So it's really, ironic that at the EEOC, which is basically there to protect employees against discrimination, that the person who is the chair of the EEOC is someone who devoted their life to representing employers at a large law firm in Washington, D.C. We know what the end result is going to be. This chairperson has already made it clear her position on EEO law, and really the goal is to eliminate any type of discrimination based on race or color or religion or national origin, and really just do away with the EEO protections. And it's going to be whittled away and done if someone doesn't step up and challenge it. So I'm hopeful that someone will step up and challenge it. Okay, so there are a couple of options that are available if you're a federal employee. For example, and I'll just use our DEI program managers and directors as an example. What happens if, for example, nothing happens between now and January 31st and they are terminated? They can either file a complaint uh, through the EEO process, which uh, here the EEO office. I don't know if the EEO office in all of these agencies will be, what's going to be the end result of that process. But you have the EEO office, and you have the option of filing an EEO complaint. Um, for those of you who've been through the EEO process, you probably understand that you have to file a complaint within 45 days of the action you're complaining about. And it is a process that's, very time consuming, and it takes, 6 months to do an investigation. And then you'll have maybe a year or so at the EEOC before you finally get a decision from the administrative judge. But your agency can definitely move forward with taking action against you, whether it's terminate you or take some other action against you. And that's really doesn't help the employee a lot. Maybe in the end, the employee can win the case at the EEOC or in court. But for those of you who are federal employees, you've spent your whole life um, working as a federal employee, that's really not a viable option to help you uh, in the immediate short term. So one option is to file a complaint with the EEOC. If you believe that you are being terminated and the agency has not provided the correct due process, either provided notice of the reasons why you're being terminated and given you an opportunity to respond, or if you think that there is some discrimination that's involved in the termination as well, you have the option of filing with the MSPB, the Merit System Protection Board. And that process is similar to the EEOC process. An administrative judge is appointed. The judge will schedule a hearing and will render a decision on in your case. And if you're happy, then that's fine. If you're not, then your case can be appealed before the MSPB. In the last Trump administration, we had an issue because President Trump did not appoint commission members to the MSPB. So for those folks who had an appeal to the MSPB and they were not successful in their appeals and they decided to challenge that before the full MSPB board, there was not a quorum in place. So their cases were just in a holding pattern, sometimes for 3 or 4 years before a decision was made, or until a new administration came in and there was a quorum and the commissioners could make decisions. So the MSPB is going to be a challenging option going forward. That's one of the points that we mentioned in the flyer. What's the future of the MSPB? It was in the last administration, it was very difficult. I recall that we had clients who had appeals pending before the MSPB, and there was no decision made on those in their cases for at least 6 years, because it started during the Trump administration, and then it wasn't until the Biden administration got maybe 2 years into its tenure that the decisions were made in at least one of those cases. The other option is filing if you believe that the action is being taken because of a prohibited personnel practice, for example, because of whistleblowing activity, or because of political activity or your political affiliation, you can file a complaint with the Office of Special Counsel. And the Office of Special Counsel will basically do an intake and make a decision on whether there's a claim that can be pursued. In most cases, the Office of Special Counsel will not assert jurisdiction over cases. And if that's the case, the employee has the right to file an appeal. And that appeal would go to the MSPB. The third, maybe the fourth option is a direct challenge in court, and that's what we're seeing most success with folks who are challenging the executive orders, and that is filing a complaint either that the action either violates a constitutional right or constitutional amendment or a law or regulation. And for I think, and this is going to be my recommendation for folks who are considering challenging um, the DEI, the decision to eliminate DEI, and that is going to be challenging the action through under the Administrative Procedures Act. The Administrative Procedures Act requires agencies who are um, requires agencies to provide notice if they intend to make any new rulemaking or change rulemaking, and it provides that the public has a right to comment on any change or any rulemaking. And if this is done without providing notice and an opportunity to comment, and then a final decision-making process, then a claim can be asserted under the Administrative Procedures Act for that the law is arbitrary or capricious or a violation of the law or violation of the constitutional rights of the individual. But to do so, you have to have someone who is impacted or affected by a decision of the agency. So it just can't be someone, you basically have to have standing to bring this type of claim. And a complaint needs to be filed in federal court in Washington, D.C. I mean, fortunately, we have really good judges here in Washington, D.C. in the federal district court. I think they are, well versed on these type of issues, these type of claims, and probably the best place in the country if this type of challenge is going to be raised. I'm a little surprised that we haven't had anyone to step forward to bring a claim under the Administrative Procedure Act for the elimination of the DEIA and DEI policies at the federal agencies. We had a question earlier this week. Okay, well, it seems like these policies are have an adverse impact on minorities because in most instances, women or minority women are the people who hold the DEI program managers or program coordinator positions. And the question was whether this is something that would be appropriate for a class action. The problem is you're dealing with any number of federal agencies, and I think it would be very difficult to have a class action that would be able to go across all of the different, let's see, hold on a second. Okay, are you able to hear me? Okay, excellent. I think it'd be very difficult to have a class action that would be able to address just broadly the elimination of the DEI offices that spans across all the different agencies. But I think that there is an opportunity for people who have been impacted in the Washington, particularly in the Washington, D.C. area to, on an individual basis, bring a claim to challenge the DEI policies. And it may be that, this type of claim will need to be raised in many different forms in many different district courts. I just don't see how it can be done as a class action that touches the Department of Defense, Department of Interior, USDA, all the different agencies that could be impacted here. All right. So now I just want to walk through just quickly what will happen, what's likely to happen if you are an employee and you're impacted by the elimination of the DEI office. Essentially, if there's no intervention by the court, on January 31st, the executive order says that these people are to be subjected to a reduction in force. So what does that look like? Um, if you are an agency employee and you receive notice that your position has been eliminated, there should be a couple of options available to you, either being placed into a comparable position. And I think that's going to be complicated a little bit in here because one, OPM has required that all of the agencies provide the names of the people who served in these different positions. And OPM, the president has also issued an executive order that's basically places a freeze on hiring. So if there are open positions, maybe your agency will move you into one of the vacant positions that's available. Should be a comparable position. But if the agency has already been required to submit your name to OPM as someone who held the position in DEI or DEIA, I think that there's a very strong possibility that your agency is probably not going to place you in another position. They will have to, it looks like they would have to justify, why Jane Smith was in this position as a director and now she's being placed into another position within HR. And from what we've seen in this administration, even in the executive orders, there's a request to identify people who were in the position on November 5th and have moved into a different position, or the title has changed, or the name has changed, or anything to disguise someone who held a position in DEI. So there seems to be an effort to target those folks. And the question is whether the person who's the senior HR person in your agency is going to authorize or permit you to move into another position if your name has already been submitted on an OPM, submitted to OPM on a list of folks who held DEI positions. So if there is a reduction in force and you're not offered a position, then there should be a offer of severance. There's a federal statute that requires some level of severance based on your years of service. I know that that's not really um, an attractive option for someone who is 50 years old and has 20 or 30 years of service, and obviously has a family, mortgage, children in college maybe, uh, and the thought of being pushed out of employment or pushed out of your position with the federal government, and you intended to remain there for the next 20 years or to retire there, that's not an option. And that's why I'm encouraging you all, someone to step up to say, we need to file a complaint, or at least if we're going to, if this is going to happen, at least I'm going to put everything that I have into it to fight it, to see if we can get a judge to hear us and um, consider our claims. And whether it's under the Administrative Procedures Act or Administrative Procedure Act or some other claim that can be made. Now, I mentioned earlier that I've heard from some of you that, for example, we have some people who are deaf or hard of hearing. We have a sign language interpreter that for some agencies, they actually house their sign language interpreters under the DEI office. If that's an option, and that is directly linked to, for example, the Rehabilitation Act, which ensures that agencies have to provide interpreters for or reasonable accommodation, or provide interpreters if needed. So that to me would seem to be a compelling case. If the elimination of your agency's DEI office is going to result in the elimination of some other program that's mandated or required by law. I mentioned earlier that Some of the DEI offices actually house all of the programs, for example, Black History Month program or the Hispanic Month program or any of the other programs. But to the extent that there are EEO services that are offered in the DEI office that are required by federal statute or required by federal law, that would be an option as well. What I'd like to see is, or to hear from you, for those of you who want to have a further conversation about this, um, I'd like to hear from you what services are provided in your DEI office and whether a claim can be made that this across the board elimination of the DEI office is arbitrary and capricious and a violation of the law. I think we know that everything that we've seen here is political, and there's been this characterization of DEI as being really a bad word or really providing, I guess, providing a door to discriminate against the majority population. Let me just say it like that, and not providing training or teaching people how to accept differences or recognize and appreciate diversity. That's how it's been characterized from a political standpoint. But agencies have not separated out inclusion training with other EEO services that are provided. So if the elimination of your DEI office is going to eliminate other programs that are required by law or by statute, that you may have a valid basis for bringing a claim to try to challenge this. All right, so those are the options. Now, we had a couple of questions about the president also issued an order that federal employees are to return to office, return to work, and no more telework. Whether that's legal, whether that's something that's federal employees are required to comply with. Generally, I'm not aware of any prohibition against requiring federal employees to return to the workplace. The exception would be if there is a, their exception would be if there is a, excuse me, the exception would be if there is a medical issue or some other type of issue that would allow you to continue to telework as an accommodation. We've had that in a couple of cases where people telework, but they did it for medical reasons, but they could do it before COVID. But of course, after COVID, when everyone teleworked, it was not an issue. But they continue to do that even now. So that would be an option. But that's something that we can probably talk you through if you want to do an individual consultation. All right, so we're going to have an opportunity to hear questions. I'll try to answer as many questions as I can. And also, we'll provide an opportunity for individual consultations. Many of you are getting packets or getting information from your agency on the changes that are taking place in the DEI office and how you may be impacted. If you would like to have us to review that, I'm happy to schedule a consultation for you to review it. And also, if you're considering pursuing a legal claim and you want to get an evaluation of your claims and whether it makes sense for you to pursue that claim, happy to do that. And then finally, we represent clients in litigation as well. Haven't really touched on employment discrimination, but just very generally, when we talk about what are your rights in the workplace, of course, you have the right to a work environment free from any type of discrimination based on your race or age or gender or national origin or a handicap. And if you believe that you are being subjected to discrimination, The first requirement is that you notify your agency within 45 days. That's a pretty short period of time. So within 45 days, you have to file a complaint or at least contact the agency's EEO office to request a counselor. And then you'll pursue the EEO. You can pursue the EEO route. Excuse me. If you're going to pursue the EEO route, it's important that and I always encourage clients to do that. We've had many cases that went to trial, and I can tell you that the cases that we were successful on were cases where the clients documented all of the issues that they encountered, all of the incidents of discrimination. So it's really important. Um, for some reason, and I guess I can understand this, the most believable evidence in most cases is the emails that document what happened on a particular occasion, your response to performance appraisals. Make sure that if there is a performance appraisal that you don't agree with, make sure you document it. And this is important to protect yourself because we've seen from from the new administration that people are going to be encouraged to identify folks to be targeted or or for removal. There's going to be a push to reduce the government workforce. So for folks who are probationary employees, obviously you want to do your best job, and that's true for all of us. But for those of us who are more senior and permanent career employees, you want to document if there are any issues, raise issues as soon as possible. Do it in a diplomatic way first, trying to resolve the issues. But if you're not able to do that, raise the issues and pursue an EEO complaint. I don't take this lightly in terms of pursuing an EEO complaint, so I don't encourage people to file EEO complaints for every slight or everything that happens in the workplace. It needs to be something significant. You don't want to, be defined by your EEO complaint. Obviously, you want to excel and be recognized for your performance. But there are people who discriminate against folks based on their race, based on their gender, based on their handicap. It just happens. And if that happens, you have to protect yourself. One of the most effective ways of protecting yourself, if there's an allegation of poor performance, is uh, whatever work that you perform, just have folks confirm whether they have any concerns with your performance, and send back an email saying, okay, hey, I just did this work on this assignment. I always like to do my best. Just let me hear your feedback on how I can improve. In most instances, people will say, oh, you did a great job. And then you have a record of someone other than your supervisor saying, hey, you did a great job on this assignment. It's hard for an employer to say you were a terrible employee if you have all these other folks saying that you did a great job on the assignment. That's one of the challenges that we have when we litigate cases is the employer will say, well, these people were not in a position, they were not the supervisor, the coworker can't comment on your work. And your supervisor is saying, oh, you were your worst employee that we've ever had. But if you have contemporaneous emails to rebut that, then that's great. And okay, so that's one issue. And then the issue is issues of conduct. If there are issues of conduct, there are certain things in the workplace that you just don't do. I was in a termination meeting just recently uh, for a federal employee who was watching pornography at work. And that's just not something, obviously, you can do. So that if there are conduct issues, definitely try to address any type of conduct issues. Now that we know that folks are going to be watched and there's going to be an effort to try to move some people out of their positions of employment, if your employer decides to pursue some type of action against you based on conduct, there is a a case. It's called Douglas v. I think it's Department of Veterans Affairs, but it lists a series of 12 factors that the agency must consider um, if they decide to take action against you, discipline against you for conduct issues. And so the um, you just want to be careful that you point that out if the agency is attempting to take action against you based on conduct. And if they haven't done that, then you have a valid basis for challenging the employment action that's taken against you if it's appealed and it ends up at the EEOC, at the MSPB. I'm just going to walk through just very quickly. If you're going to file an EEO complaint, of course, I would be very careful in filing an EEO complaint, but if there's direct evidence of discrimination, you definitely want to file an EEO complaint. If someone has said something to you or has put something in an email that directly implicates your race or your age or your gender, your sexual orientation, or the fact that you file an EEO complaint, that's direct evidence of discrimination. In the absence of direct evidence of discrimination, your courts are going to look for circumstantial evidence of discrimination, and that includes um, whether the reasons given for the action that's being taken against you, whether the reasons are true or false. If you can somehow show that, hey, I was not terminated because of my performance, because all of these records show that my performance was satisfactory, that's pretty persuasive evidence, at least part of the evidence that you will need to prove that that you were subjected to discrimination. So that's one option, just that the reasons given are false. The second type of evidence that you would look at is whether there's evidence that I'm being treated differently than someone else who is, similarly situated. So particularly someone outside of your protected class. The third option is a third type of evidence is whether the employer followed its policies and how I was treated. That's always a very persuasive point. If the employer has a set of policies in place that says, this is how we make decisions for selections, and they don't follow the policies, or this is how we discipline people. We provide progressive discipline, or these are all the other policies that we follow in the workplace and they're not followed. And then the final point is whether the employer provides a changing or shifting explanation for the action taken against you. So if you have that type of evidence, and that evidence will be persuasive, and in most instances, it will allow the judge to either rule in your favor, or if your case is in court, allow the case to proceed to a jury trial. So I've kind of walked you through, that's the evidence that you can expect to submit if you have an EEO claim. So for example, if you think that you're being targeted for elimination or targeted for termination, you want to start thinking about, has someone said anything to me that suggests that this is because of my race or age or gender? Or am I being treated differently than a colleague? Is the employer, is the agency following its normal policies in how it's treating me? Are the reasons actually false that they've provided? And have they changed or shifted their explanation for the actions taken against me? Thank you. Okay. So I do want to take some time to hear questions. I'm trying to think through the best way to do this.
Okay. Attorney
Okay,
Branch. Hi.
good.
So we have over 200 questions in the
Oh,
Q&A section, and I've written some down. So I can ask you, and we can just do it that way to make it simple.
yes, why don't we do that?
All right. Number one, since DEI covers veterans and people with disabilities, does this not trigger the ADA to step in?
Yes, and so that's one of the points that I made earlier, if when I gave the example of the clients who are deaf or hard of hearing, and in their agency, DEI covers providing interpreters. So yes, my answer to that question would be yes. If your DEI office has responsibility for other programs that are protected by other federal statutes, then there is in my opinion, there's likely to be a valid claim to challenge DEI for your agency. Now, a judge is going to have to make the final decision, but I think you have a compelling case. I mean, I don't know how you can have an agency without the protections of Title VII of the Civil Rights Act, all of the discrimination statutes. I don't know if your agency has plans to move those programs out of DEI and into another office. And I think, the problem really for DEI is agencies have basically, in my view, shifted the EEO function under DEI. And that's something I don't think the administration appreciates, that basically EEO functions and duties are now being performed under the umbrella of DEI. So yes, I think that there's a valid basis for challenging the DEI elimination of DEI at your agency if the ADA or the Rehabilitation Act or one of the other federal discrimination statutes is being addressed in that office. Okay.
What if you realized you were discriminated against and weren't aware of the 45-day EEOC interval and feared retaliation?
Okay, that's a good question. And we have that on occasion. Yes, there's a 45-day period, but it's an administrative period. It can be told, meaning for any claim, it doesn't really start until you have knowledge of the claim. So you can still make an argument, an equitable argument, that this 45-day period should not run because I didn't learn about this until day 100, and I'm filing within 45 days of when I learned about this. When I learned about the discriminatory action. I don't know how far you're going to get with the claim that, you feared retaliation. And I guess you can make that argument, but the better argument to make is I was not aware of the discrimination until, this particular event triggered it. And there are judges who will be open to that type of argument. There's definitely case law to support that. Okay, Kaylin. And while Kaylin is pulling up the next the next question, I'll just say once again, if you want to, I'm happy to have a private consultation with you. Just go ahead and email me or email Kaylin, and we can get you scheduled for a consultation. If you're going to do a consultation, the first thing we always do is just ask you to give us a short summary of what the issue is, and any documentation that you'd like for us to review. So you have the option of a consultation. We can give you the fees that are involved in that as well. You have the option for consultation, the option for a case evaluation, where we will look at all of your evidence and advise you, or basically help you evaluate your case, to help you decide, okay, well, what are the strongest claims, or what additional evidence do you need to support your claims? And if you're going to pursue this, what's the likelihood that you're going to prevail in light of the claims that you've raised? Okay, Caitlin.
Okay. Can you please speak to the executive order regarding employees still in the probationary period? Is there a legal standing to file a complaint about that?
Okay, so I need additional information on the employees who are still in the probationary period. So I'll need to ask that person just to send me an email on that point. I don't recall seeing anything in the executive orders that I reviewed that dealt specifically with how employees who are in their probationary period are to be treated. I didn't see anything that said you need to remove or you need to terminate these folks.
How does this policy impact individuals who are hired as full-time remote employees?
The one point that I did not address is there are collective bargaining agreements, and there are other agreements that should stand above this, executive order. So, and this is true also for people who are contractors. We got a question earlier today from someone who said, okay, I'm a contractor and my contract was terminated. The fact that there's an executive order should not nullify any collective bargaining agreement, any specific terms that were in your hire letter. For example, if your hire letter, offer letter was 100% remote, that should be binding above this executive orders. And if there is an effort to challenge or to force you back into the office when you have a contract, a binding contract, then that's an issue that will have to be resolved or decided by the court. I don't think this executive order can go above and beyond any contract that you've entered into with the agency, either through a collective bargaining agreement or through even a contract if you are a contractor, or if you're an employee and you signed an agreement for 100% telework. Okay, Kaylin.
Where does the union fit into the new executive orders?
That's a good question. And I don't see the union anywhere in the executive, or at least the executive orders that I've reviewed, at least how it applies to elimination of DEI offices or any agreements that the agencies have made with the unions. So this is something that should be front and center for your union if the agency tries to take action that violates an agreement made by a collective bargaining agreement. So yes, that's a valid concern, and it should, if you're in the union, you should consider challenging this if it violates the collective bargaining agreement, or if you're a union member, raising it with union member leadership that, hey, this violates the we bargained for this, and I don't think an executive order can nullify what we've bargained for.
Many individuals have been told that the EEO office is not open for them to file. Is that true?
Wow. I hope that's not true, but if it is, if that's what the agency is saying, then that's definitely something that needs to be raised with the court. I mean, you have your agency is required by statute to receive EEO complaints. They can't close the office that accepts EEO complaints. So this is something, as I said, there are many issues with these executive orders. Of course, the agencies were caught by surprise. And if they house their EEO office in the DEI office, and now the person running the DEI office is no longer there and the DEI programs are all going away, that's a problem for the agency that exposes it to liability. What I'd like to see is just someone step forward and say, let's challenge this, because the closing of the DEI office has closed out access to the EEO process for all these employees at my agency.
The anti trans executive order will violate the rights of trans employees. How do we fight that?
Okay. Well, there are a couple of ways to fight this. I think one is through the EEO process. And also, I have not focus on the specific executive order that deals with trans people, but one may be an equal protection constitutional argument as well. A lot of these issues are going to have to be sorted out in the court. Right? It's unfortunate that that's what's going to happen, but it seems like the administration has made a decision. We're going to, set off so many fires that people are not going to be able to combat all these fires at once. So that's why we have whatever 200, executive orders. But there are options available for challenging any order that discriminates against anyone, whether it's through the EEO process or through one of the constitutional amendments. But that's something that you probably need to consult with an attorney on if that's something that concerns you.
What are options if released from duty for pay? Are we able to claim unemployment with the Department of Labor until we find employment? Where does the DOL stand on the unemployment compensation?
Okay, so if you are terminated, for example, if there's a reduction in force, there should be severance pay. For the period that you receive severance pay, you would not be eligible for unemployment benefits. But if you're otherwise terminated for anything other than misconduct and maybe gross misconduct, but if you're terminated because your position is eliminated or even for performance, you would be eligible for unemployment. So you file for unemployment you file for your unemployment with your state unemployment office. You should be eligible for unemployment benefits unless it's gross misconduct or you quit or resign from your position.
Is it correct that Biden signed an executive order for working from home until 2029? If so, how is the new order possible or legal?
Okay, I'm not exactly sure of the date that the President Biden's executive order continues, but what we've seen so far is once the president is in office, that president can, I think one of the first things President Trump did was reverse a number of the Biden executive orders. So an executive order is not a statute. It's not a regulation. It's not a law passed by Congress. So I can't say that one executive order is above any other executive order. So if President Trump issued an executive order revoking the executive orders that go beyond President Biden's term, legally, I just can't see a court weighing in and saying President Biden's executive order is to be enforced beyond his time in office.
Okay. Often, when an employee loses his job, he is not able to afford the retainer due to no income coming in. Will there be a class action lawsuit instead with similar discrimination type?
That's a good question. I'm hopeful that there will be a class action lawsuit addressing most of these issues. I really want to see a class action lawsuit on the executive orders that deal with DEIA and DEI. And I'm open to talking to other attorneys and pulling together resources. I mean, one option may be, we haven't gotten to this point yet, but one option may be, giving those of you who are able to help contribute to the cost of litigation, giving you the option to kind of come together and we've had some success in the past where people kind of came together and helped funded the litigation There are law firms that are filing class actions, and the issue is just going to be, whether there are resources to meet whatever defense is going to be presented in responding to any class action. I mean, the first thing, what I'd like to do is see a temporary restraining order, just have a court put the brakes on the executive order until it can be heard on the merits. And what the points that you've raised in this, in some of your questions already suggest that a lot more goes on in the EEO, in the DEI offices than just, training or bias or whatever people think takes place in DEI offices. It looks like a lot of agencies house their other EEO programs in the DEI offices. If that's across the board, then maybe there's a valid basis for bringing a class action just to challenge the executive orders that deal with the elimination of DEI positions and DEI offices. But if it's true, what I suspect, that every agency, it operates differently. In some agencies, there may be an EEO office, and other agencies, all these functions are under the DEI office. It may be a little difficult to convince a judge that all of these issues should be heard together. But it's possible. I haven't really explored that fully, but I think that that's something that definitely needs to be considered. But the problem is, in a week's time, most of the people who are in DEI offices, well, the DEI offices have already been shut down, but the people who are in those offices will be out of their positions. But for the other federal employees who have no option for filing their EEO complaints, that should be a problem.
What impact, if any, will the DEIA EO have on EAP services?
Okay, I think it depends on your agency, because maybe some agencies even include their EAP services within the DEIA office. It sounds like from your question that the DEIA office includes the EAP services. So if that's in fact true, and for those who are not familiar with EAP, I assume most of you are, it's just employee assistance programs for that agency set up to provide whether it's mental health counseling or therapy or other health sessions to help employees. I mean, I don't think those are required by law. They may be, but if they're not required by law, it would be difficult to use that as a basis to challenge the elimination of the DEIA services. But it's a problem for the agency if they have EAP programs and they were in the DEIA office and now the DEIA office is no longer there. I mean, that's a problem for the agency. It just seems like the agency would be concerned. What are we going to do about our EAP program now that DEIA is no longer here? These are all issues that I think, of course, the administration just came on board on January 20th. So obviously they didn't even know, how these programs were functioning within DEIA. But it may be a valid basis for challenging it.
Should people invest in professional liability insurance?
I've heard that before. So let me just say, generally, the regular, GS 5, 7, 9, 11, 12, maybe 13 employee probably should not. But if you're a manager, I think that it may make sense to do that. And I'll say that because we are now, we've entered an era where agency senior management is not necessarily going to protect the GS 14 and 15 or even to some extent SES employees. We've had a couple of cases where agency management basically turned on senior managers because they wanted to find some reason to, get these people out of their positions. But now we see that with this administration, they are actively going after senior people in the government and looking for reasons to, get rid of people who may not be loyal to the senior people in the agency. I mean, I think, for example, we only know who knows what's going to happen with the Department of Defense since there's a new secretary. A lot of people were not particularly in favor of this new secretary, and there's going to be an effort to probably root out people who may be considered to be disloyal. And how do you do that? How do you get rid of senior managers? You find subordinate employees who will come forward and say, hey, this manager was a terrible manager, or they mismanaged, or they abused their process, abused their position. If that happens, then it's probably a good idea to have insurance if you're going to have to defend yourself. I'm saying that just giving an example. I don't know for certain that that will happen, but I can foresee that happening.
Is there a statute that I can point to for continuing as a remote employee pursuant to my hiring agreement? The job was advertised as a remote job and I accepted it as a remote position.
There is not a statute, but basically you have the terms of the vacancy announcement. All of these things would be part of your contract. Vacancy announcement, the offer letter, all of that should say this is a remote position, 100% remote position. It's advertised as a 100% remote position. And because it was advertised, I accepted it. Basically, it's a breach of contract claim. I relied on the representations made that this was a remote position, and now a decision. If this happens, I don't know if they will actually try to force you back in the office, but if this happens, you can rely upon that to say, now they're forcing me back into the office. And so it sounds like you may have a legal claim if they try to do that. But you're probably going to, if they do that, you're going to, and they're not convinced or persuaded by you or your lawyer telling them that they're dead wrong and they're violating the terms of your terms that you accepted when you took the position, then it's going to have to be sorted out in court.
If you're eligible for retirement, would it be easier to take that route instead of being riffed?
If you're eligible for retirement, well, it depends on what are your plans. Are you truly planning to retire, or did you plan on working another 5 years or 10 years? If you plan on working another 5 or 10 years and you really hadn't planned to retire, it's probably better to be RIF, because if they RIF you, then one, you're probably entitled to severance pay. And what happens when there's a reduction in force, the agency is required to prepare a retention register. And that says that these folks are being RIFed if for whatever reason, if you're in a particular category, and if positions become available, then they have to bring you back into that position. So if you're really ready to retire, then that's fine. But if not, I would say, go through the RIF process, if they can't find a position, comparable position, get your severance, and then you'll still be on a list of folks to be brought back if you still want to work.
Can you explain the difference between DEI, DEIA, Rehabilitation Act, and ADA?
Okay, let me start with the easier point. All right, so let me just of course, DEI is diversity, equity, and inclusion. And just trying to think DEIA is diversity, equity, inclusion, and accessibility in the federal workforce. I don't think that there's a significant difference between DEI and DEIA. It's just the terminology that's used um, for some of the federal agencies. Now, as far as the differences between ADA and the Rehabilitation Act, the Rehabilitation Act um, it applies to federal employees or entities that receive funds from the federal government. The Americans with Disabilities Act is basically the statute that covers discrimination or individuals who have disabilities. And basically, the Rehabilitation Act says that we apply the terms of the ADA, which basically means that agencies can't and employers can't discriminate against you because of a disability. And if you have a disability, that they can, and you can perform the essential functions of the job, they have to provide a reasonable accommodation as long as it will not create a hardship for the agency. So ADA and Rehabilitation Act are basically intended to address the same issues of disability discrimination. ADA is the broader statute that's for the private sector. Rehabilitation Act applies specifically to federal agencies and entities that receive funds from federal government.
My paid parental leave is just ending. In accepting that leave, I sign an agreement to continue working for my agency for a year, or else I would be required to pay back my salary during that leave period. How is this impacted if I am terminated?
Just repeat the first part of the question. Well, why don't you repeat the whole question again? Because
Sure
I
thing.
missed the first
And I'll
part.
put it in the chat.
Okay. Let's hear the question again.
Sorry, and I'm also putting it in the chat.
Okay.
My paid parental leave is just ending. In accepting that leave, I sign an agreement to continue working for my agency for a year, or else I would be required to pay back my salary during that leave period. How is this impacted if I'm terminated?
Okay. So basic contract law says that no party can take any action to cause the interference with the other party completing the terms of the contract. So if you have a contract and it requires you to do something, the other party has an obligation not to take action that will interfere with you completing your performance. So if you're ready, willing, and able to complete your performance and work the next year, then that satisfies your obligation. If the employer comes back and says, well, no, we're not going to allow you to work the next year, we're going to terminate your employment. I don't think that they can make a valid claim that somehow you owe them something when it's totally beyond your control and they made the decision to end your employment before you could repay them.
Should one desire to proceed with filing a action lawsuit, the EL pertaining to DIA, what is the average cost considering the scope?
Okay. That's a challenging question because it depends on if a claim is filed in federal court and you're able to pursue it in federal court, or if it's an EO claim and a federal, and it's begins at the federal agency, it has to start there. So you'd have to file with your agency's EEO office. Then you can, after 180 days, you can either file in court or you continue with the EEO process through the EEOC. If the claim is filed with the agency and then it goes to federal court, you will not have to go through the entire process at the EEOC. So it's a little challenging to answer that question because I don't know how many hours will be involved. I'm happy to share what we charge on an hourly basis for the work that's done for the attorneys in our office. If you want to email me, I can provide that information to you. And I can give you an estimate. Once you tell me exactly what you're trying to accomplish, I can probably give you a pretty good estimate of what the costs would be involved in doing so.
A few individuals are going through this similar situation. One user says, as of this message, I have not received an official notification from my agency stating I would be placed on administrative leave due to the executive order. However, I have been stripped of all access and told verbally that I have been placed on leave. How should I handle this matter at this time, not having received written or official notification?
Yeah, that's a good question. I think the best way to address this is just to document this. I mean, and now that you're locked out of your email account, you're probably going to have to do this from your personal account. Just document that you were given verbal notice that you were placed on administrative leave. If you want to cite the executive order, we can probably get a copy of the executive order, and you can actually Google this as well. It's the executive order issued, well, not the executive order, but a memorandum issued by the Office of Personnel Management on January 21st, 2025, regarding initial guidance regarding DEIA executive orders. And that sets out the procedures in place. So if they're required to provide this. They were supposed to provide you written notice. They failed to do so. And if they come back at the end of the week and say, here's your, termination, that's going to be another issue that can be raised if you decide to challenge this. And I know for those of you who are facing termination at the end of the week, you have a difficult decision to make. You can wait and see what happens to see if you're going to be riffed, as it looks like that's what the executive order is saying, or make some attempt to try to challenge it before the end of the week. And I know that that's probably going to be difficult. I mean, it's really unfortunate that you have, maybe 10 or 11 days to make a decision about something that could impact you the rest of your life. Um, or you're going to be on this RIF notice and be separated from the agency. If you decide at some point after you receive the RIF notice to challenge it, then you'll have a procedural basis for challenging it. As I mentioned before, I think that the agencies are violating the Administrative Procedures Act by eliminating these DEIA offices without providing notice and giving people an opportunity to comment and then making a final decision. You just can't make decisions like this that impact agencies, at least in my view. Can't make decisions like this that impact agencies without following the Administrative Procedure Act. So to answer your question, I think that you should document that you have not received a written response or a written notification. All you've received is a verbal notification, but you're being told that your position is going to eliminate. And it just does not meet the requirements, either from what was issued by OPM or from federal guidelines under the Administrative Procedure Act.
What about veteran employment? My position was placed there. Am I protected?
Your position should be protected. Well, I assume you're asking about if you're a veteran employment, you receive some type of veteran preference, and you're in a DEIA position. It really depends on the agency. It sounds like you may have a legal claim, but if the agency decides that because you're in this office and there's an executive order that says that everyone who works in this office is to be placed on administrative leave or to later to be RIFed, then your agency may go forward with this. But I think you're going to have a claim if the agency takes some action that violates law in carrying out this executive order. But again, you're going to have to challenge that either before the MSPB, because that's going to be the next step, or you can challenge it in the Office of Special Counsel as a prohibited personnel practice. I'm not exactly sure if that would cover folks with veterans preference. I'd have to check that, but you should have an option to challenge it at least before the MSPB that you were removed through this executive order, even though you were placed there because of the veteran's preference.
Approximately 30% of USAID's 10,000 person workforce is made out of institutional services contractors, ISCs. The foreign aid pause means that all of the ISCs are being furloughed unless a special waiver is administered by the Secretary of State. Are there any protections to ISCs even though they are not direct hire?
Wow, that's an excellent question. And I don't know the answer to that. And I just don't know where to even start to answer that question. But it's something that I'm happy to, work with you to try to find the answer to that. But I had no idea that all of the people at this agency were basically contractors. Um, I'm sorry, I don't know the answer to that. But if you want to reach out to us, we can work with you to try to get an answer to provide some guidance to that. But there should be, I mean, it's difficult to imagine that well, I just don't know the answer to that, that they could just, terminate the that they could terminate the contract without any consequences for a contractor.
Are the rules against discrimination cemented into law? I had heard that one of the president's executive orders eliminated protections from discrimination because of one of the protected classes.
Okay, so Title VII of the Civil Rights Act protects against discrimination based on race, sex, religion, national origin, and it protects against retaliation. Other statutes protect against age discrimination, for example, or disability discrimination. I believe that there's an executive order that addresses discrimination beyond what's included in the Civil Rights Act. That could be, sexual orientation or maybe even genetic information. I don't want to, provide a specific response to that, but I know that there are executive orders that extend discrimination beyond what's provided in Title VII of the Civil Rights Act of 1964.
What is the cost of a consultation fee?
The consultation fee is $350.
Do you have any rights as an HR competitive status employee in the federal government? I thought it was difficult to fire federal employees.
It is difficult to fire federal employees. Obviously, if in the private sector, people are at-will employees, which means that you can quit or you can be terminated for any reason or no reason. In the federal sector, and I'll touch on this in a minute, in the federal sector, once you get beyond your period of probation, you become a permanent career employee. And basically you can be terminated, but it has to be for cause. You have a property interest in your position. You can't be denied it without cause. But that, what constitutes cause, it still has to be decided by an administrative judge. So the MSPB has decided, for example, if you're being terminated for performance, that you have to be placed on notice of performance issues and needs to be a performance improvement plan. And before they can take this action, they basically need to document there was a performance issue before you're placed on a performance improvement plan and then terminated. If there's a conduct issue, that's different. So you have performance and conduct. If there's a conduct issue, basically the government can terminate you, to promote, the efficiency of the government. For example, I gave this example recently of someone who was watching pornography, at work, and the government said, okay, we're terminating you because you didn't follow our policies, and this is for the efficiency of the service. If that's the charge, then your claim will proceed before the MSPB, and a decision will be made on whether your termination was warranted. So it is challenging to terminate a permanent government employee, and I don't want to say most, but many government employees are in unions as well. So you have terms and requirements from the collective bargaining agreement, but there needs to be either a conduct issue that the government can justify as terminating you because of this single offense, or there needs to be a performance issue that hasn't been addressed and you've been given an opportunity to address. So assuming you don't have any conduct issues and your performance is meeting the requirements for the position, there should not be any justification or any reason to terminate you, other than, for example, the elimination of your position. And that's what's taking place with the reductions in force for the DEIA positions. A decision has been made that these offices will no longer function, and the people who are in these offices are no longer needed in their positions. But as I mentioned earlier, even if there's a reduction in force, there's a requirement to place people on a retention register and consider placing them in comparable positions. Now, if you reject a comparable position, then you can be terminated. But assuming you will accept a comparable position and you're offered a comparable position, then you will not be terminated.
What are your thoughts on this new administration possibly severely reducing the presence of the union? Does this violate any constitutional laws considering the agency is under a contractual agreement with the union?
I think that's going to be challenged in court. I mean, these unions are well lawyered up, and some of them are preparing for that. If there are collective bargaining agreements that are in place, I think it's going to be very difficult for an agency to say we're just not going to honor the collective bargaining agreement, or it's going to be nullified. And I would be shocked to see a court rule in their favor in any effort to try to eliminate or nullify a collective bargaining agreement.
What about employees that were formerly in a DEIA office but were moved to a new office yet still identified for administrative leave in RIF? Is this able to be contested?
Okay, so the executive order attempts to address that by saying that if someone was in the position as of November 5th and they've been moved to another position, the memorandum from the Office of Personnel Management requires that the agency disclose the names of those folks. And to me, that's a problem when you have agencies disclosing to OPM the actual name of folks who held these positions. So that may raise some type of legal claim on behalf of for the employee. But it seems to cover folks who were in the positions and were moved to other positions. And that seems to be the point of it. This administration saying we want to rid the agency completely of people who held these positions, which to me seems to suggest that people are being targeted. But if no one challenges this and it stands, and I just know that at some point people are going to challenge it. It's just a question of whether it's challenged before people are rift, or if people challenge it after they are selected for separation.
Is it accurate that when an IRF is processed, an employee must be given 60 days notice? Does this mean that there would be 2 months until the employment was officially severed?
What is the word IRS?
RIF.
Oh, a RIF, a reduction in force. Okay. So we had this question earlier. In the private sector, there's something called the WARN, WARN. That's the acronym for it. And it requires employers to provide, I believe, 60 days notice if they're going to have a reduction in force. I'm not aware of anything that's required under federal law, and particularly when it comes to individual reduction risks or reductions in force that only affect a small number of people, that requires a 60-day notice. I have not seen it. I practice in the District of Columbia, and the District of Columbia models its personnel management guidelines after OPM. We've had many RIF cases. I've not seen anything that required the government to provide 60 days notice before going forward with a reduction in force.
Why haven't the other branches of government intervened yet?
Okay, so the other branches of government would be the legislative branch, which is controlled by Republicans in the House and Republicans in the Senate. And the other branch of government is the executive branch. And the executive branch, not the executive branch, the judicial branch. This is obviously done by the executive branch. The judicial branch is waiting for claims to be brought. It's not going to go out and um, pursue claims or create legislation. People have to bring a complaint before the courts, and the courts will decide. I mean, that's the beauty of it. What happened with the claim that was in the state of Washington, and the claim that's being brought now by Public Citizen concerning the creation of this Department of Government Efficiency. You have to be someone who has standing, and you bring the claim saying, I've been harmed by this particular decision, and bring it before a judge, and a judge will make a decision whether, and I didn't touch on this earlier, but if you're trying to get a temporary restraining order, you have to show that there's basically a violation of of a statute or a law or the Constitution, that you will suffer irreparable harm if the issue is not addressed, that there's a substantial likelihood that you will prevail on the merits of your claims, and that the public will benefit. So it's getting a TRO or an injunction. It's an extraordinary action, but I think that there are judges in this court, at least in the District of Columbia, that would seriously consider a TRO um, against some of the executive orders, if they in fact implicate what we've heard here tonight. If, for example, the disability discrimination statutes are applied through it, or the EEO responsibilities are carried out through the DEIA offices, and those are dismantled. And so the agency no longer has a process to receive EEO complaints. That's a um, pretty serious matter. I think you will probably find a judge who's sympathetic to that type of argument if that's what's actually taking place at your agency.
What about supervisors who use their position of power to make up lies about the employee's work performance, often making it harder for the employee to fight back regardless of a mountain of evidence? HR's primary focus is to protect the employer, secondary the employees. This case
Yes.
makes it harder to sue and individuals often lose in court. So, the Trump administration is asking for a list of employees to terminate. How can we protect ourselves from corrupted supervisors?
Okay. Now that's an excellent question. And I can say that I've been doing this, practice for 30 years, and we've had a number of cases where we represented clients and the supervisors did exactly what you've just said. They colluded to decide that, hey, we're going to get rid of David. We're going to paint him as a terrible employee, and we're going to lie and do whatever we need to do to get him out of here. And now that the concern is real, since this administration is saying, okay, bring us folks that we can get rid of. All I can tell you is what I said earlier is the most important thing is actually to do your job and to document your performance if there's an effort that you believe to paint you as not performing or having performance or conduct problems. Just to provide contemporaneous emails. I'm not saying spend all your day writing emails or going back and forth with your supervisor. But if you have a meeting, it's never a bad idea to just kind of summarize, look, we had a meeting and this is my understanding of what was communicated and the expectations. And if I've missed something, please let me know. And then, once the assignment or project is completed, I was assigned tasks A, B, and C. I'm confirming that I've completed tasks A, B, and C by the due date or when it was done. Let me know if there was a problem. It's really hard for people to go on the record and lie in emails. I mean, they will either ignore it, and so then you have basically the equivalent of what's considered to be an admission because they didn't respond to it. Because when you take the stand, my question will be, did you send an email? Yes. Did you lay out all these issues? Yes. Did you get a response? No, there was no response. All right, and then the question goes back to them, well, why didn't you respond to this if you had all these issues with this person's performance? So that's how I think the best way to protect yourself. That's where we've had success in presenting claims when people had records to confirm that they were doing their job, meeting the expectations, and you were able to paint your supervisor as being, untruthful or not reasonable in their expectations and criticism of you.
This latest OPM memo from Friday night states agencies can and should begin issuing RIF notices to employees of DEIA offices now. Agencies are reminded to define the competitive area solely in terms of the DEIA office where the employees worked. What does competitive area mean in this context? What if this is the first of DEI related jobs we've held and our experience is in something much more generalized, such as administration or data?
Yeah, wow. I think that document would be my exhibit number one in my case against the agency and against OPM. It sounds like OPM is trying to put their thumb on the scale and say, look, get rid of these people, and you're reminded that the competitive area can only be DEIA, when in fact it should, from the question that was just asked, it should include other areas because you're performing duties beyond other areas. Um, I think that's definitely something that needs to be challenged. If this person is going to, if whoever you are who asked this question, if you're going to, challenge this decision, I would document, here's my concern. I perform other duties. Make sure you go on the record as saying, I do not agree with or I object to this characterization of my work is limited to DEIA when, I perform all these other duties. Here's my performance evaluation, or here's my performance plan with all of these other things that are assigned to me. And in fact, the DEIA duties are just, an additional duty, or, 10% of my time. So I'm disputing that, and make them come back to you and either not respond so that, you have this if you need to challenge it, or have them come back to you and respond by either admitting that, hey, what you're saying is true, or trying to say that what you're saying is not true, which of course you have evidence to refute that. So, but no, I think you're thinking exactly how you should be thinking. I was not aware that there was a further guidance issued as late as Friday directing agencies to, place people on this retention register and limit them to um, the competitive area to just DEIA, which, yeah, I'd like to see some of this. And so if you all have these documents, if you want to go ahead and send them to me, or if you have a note that you want to follow up with, go ahead and send that to me. I'd like to see that, because I assume that if OPM sent that to your agency, they sent it to all of the agencies. I mean, the more we talk about this, the more this sounds like a big class action. If all of the agencies are taking the same action against employees based on this guidance or direction from OPM. And we cut back some of the content tonight because we recognize that there's a possibility, because the way we communicated this information, that we may have some folks who are listening who don't have the best interests of those folks who are the victims here at heart. So I'll just, leave it at that. I hope those folks are well, but I don't wish ill of anyone. But I know you all are here because most of you are here because you're genuinely concerned about your careers, and um, even more concerned about what's going to happen to DEIA at your agency. A lot of the agencies are desperately in need of these programs, and the thought that they're being cut or eliminated and the people responsible for administering them is very troubling.
Our division gave up its office during COVID, so we technically do not have space to return to. We are fully remote. If we can't find space, does the administration have grounds to let us go?
Yeah, I think what I saw in one of the earlier executive orders was basically an out for the agency. Use your best efforts to bring folks back into the agency. We have this. I have this with some of my clients, that they're working remotely and they haven't been in the office since 2020, and the agency doesn't have office space for them. So I can't see how the agency can possibly go forward with a reduction in force, or force people. Well, I don't say reduction in force, just I did mean reduction in force. I don't see how they can force people to come back into the office when they don't have space for them.
Are benefits like short and long term disability or FMLA leave at risk?
They should not. That's again covered by FMLA, is covered by statute. The benefits should be covered by contracts. So anything that's covered by statute should not be at risk, and anything that the agency is obligated to pay through um, OPM or retirement benefits, that should not be in jeopardy.
When an attorney is hired, the agency feels threatened. Retaliation follows, termination follows. So is it worth suing?
Well, I think it's definitely that's really the only option that you have if your agency is, either discriminating against you or has plans to, to somehow target you or to get rid of you. I think that when you hire an attorney, of course, the agency is going to get its attorney involved, and it knows that someone is looking over its shoulder and it's going to question everything that they do. So I think that that's helpful to you. Um, it's unfortunate if the agency retaliates, but once again, the agency legally can't retaliate. If you're an employee with um, issues with performance or issues with conduct, there's nothing to prevent the agency from taking whatever action it would normally take for an employee with performance or conduct issues, but it should not retaliate against you. And it should be easy to determine whether the agency is retaliating against you or whether this is because of performance or conduct. You should be able to prove that your performance is meeting your performance expectations or performance goals, and you definitely should be able to, address any conduct issues. We're going to take maybe about 15 minutes here and then wrap up. I know that we had 200 questions. I don't think we can get through 200 questions. I have to decide how we're going to proceed in the future here.
Originally, we were told that the Office of Minority Women Inclusion offices were safe due to a federal regulation dated back to 2011. Now we are told that these offices are closing as well. Do you have any insight on this?
Okay, so if there is a statute that says, I mean, the executive order does not have authority to overturn a statute. So I would have to see, where is this prior policy that you're referencing? Where is it codified? Is it in a agency regulation, or is it in some enabling regulation, or if this is a prior executive order? And if it's a prior executive order, I don't think there's a problem with an executive order overturning that. But if it's in a federal statute or some other regulation or law, then it is a problem. So that's an issue that you would have to, an attorney would have to sit down and look at both the prior regulation or policy and this new executive order to see if there's a conflict that can be, I guess, resolved. And if not, you're probably going to have to pursue a legal claim if you're going to challenge that.
Can they retroactively fire folks who were hired through the Schedule A pathway?
Retroactively fire people, and I think we need more information on that. Retroactive to November 5th or retroactive to some date before November 5th. Once again, just like the other points that we raised, if there is a overriding agreement or contract that led to you being hired, that should govern and should be binding above this executive order. So, for example, if you had to file a claim, your claim would be, hey, I can't be subjected to this objective order, this executive order, because the schedule that I was hired under permitted me to be hired, and it should not be subject to the executive order. There's a binding agreement that precedes this executive order.
Aren't DEI divisions funded by Congress, which would require congressional approval to close?
I don't know the answer to that question. That's an excellent question. I think that it really depends on how your DEI division, how it's constituted at your agency. We talked earlier about different programs, different types of EEO programs being brought under DEI. So I don't know what the source of funding would be, but that's something that you can probably find out. What is the source of funding for this DEI program? Is it, through Congress, or does it come from elsewhere within the budget of the agency? And if it comes from Congress, then that could be a problem, just eliminating it.
This has been so helpful. Do you plan to have these in the future? If so, what is the best way to be sure to know about it? Will you have something on your website we can monitor to be sure we don't miss any future webinars?
Okay, I think Caitlin, you may have to answer that, but the legal assistant will probably have to answer how we're going to do these in the future. But we have your contact information, and we'll certainly do this. I think we're probably going to um, do another webinar probably sometime in the near future, because I'm really monitoring what's going to happen over the next week with the deadlines to eliminate the DEIA offices and to reduce those folks, and if there's going to be any legal challenges to that. And also, as I mentioned to you before, if you need a consultation, or if you want to schedule a consultation, just let us know. Or if you want us to do a case evaluation or a case review, happy to do that. And I think I mentioned to you the hourly rate is $3.50 an hour. We usually take a couple of hours to do the case evaluation, and then the representation if you decide that you need assistance with your claim, or someone to review your separation package if it looks like the agency is going to move forward with separation, and help you decide whether you want to pursue a claim.
Yes, I would like to also add that we have all of the visitors' information. We'll send a follow up email with the webinar link that will be recorded this evening. We will link our social medias and you can follow and stay up to date through that as well.
Great. Thank you.
Mhm. Are you helping clients who work and reside in Maryland or only in DC?
Maryland as well. I practice in Maryland and in DC. I actually have a outdated license in Pennsylvania, but we do practice in Maryland and DC. We consult all over the country. We have cases at the EEOC and MSPB throughout the country, so that's not an issue if your case is pending before the MSPB or the EEOC. If your case needs to go into a court in a state other than Maryland or the District of Columbia, then you'll need to get local counsel there. But we have clients who are in Michigan, Chicago, California, Florida, all over. I don't want to say all over, but throughout the US, if their cases are pending before the EEOC or the MSPB.
Would you be able to deliver the same session for an employee association? And do you take speaking engagements?
We do take speaking engagements. Happy to bring this information to your employee organization as well. Just reach out to Kaylin and we can work on that.
If we are remote workers outside of the DMV but want to pursue federal court with you, can we?
If you are a remote worker outside of the DMV, but you want to pursue a claim in federal court, yes, you can. But it depends on your agency as well and where your agency is operating from.
I believe that sums up a majority of the questions. One last question could be, can you provide your contact info and do you work with unions?
We do work with unions. We can provide our contact information as well. Kaylin, if you want to put that in the chat, if you don't mind.